Okay. So, we are now on Module 13, no? Na parami yung discussion natin sa Module 12. Okay? But, then again, those are very common crimes, no? Malversation and bribery. So, now to Module 13, destruction of life, no? Um, Parricide, murder, homicide, ano pang discuss? Discharge of firearms, infanticide, yun. Marami siya, but very easy lang to understand. Very common crime eh. So these are very common crimes. Okay, parricide. What do you mean by parricide? You kill your one of the family member, no? The person is killed, that the deceased is killed by the accused, that the deceased is the father. So the victim, no, or the deceased or the victim must be the father of the perpetrator, the mother of the perpetrator or accused, the child, whether legitimate or illegitimate, or the legitimate other ascendants or descendants, or the legitimate spouse of the accused. Okay, what is very important here is the relationship, no? For example, a killer is liable for parricide if the killer kills his father, mother, legal spouse, meaning married sila dapat, hindi pwede common law wife or live-in partner or kabit or girlfriend. No, that is not parricide. That can be homicide or murder, but not parricide. They must be legally married. The spouse or the wife or the husband must be legally married with each other for parricide to take in. Children of the killer, either legitimate or illegitimate. Other legitimate, again, legitimate ascendants or descendants, not illegitimate ascendants or descendants. Sir, what do you mean by legitimate ascendants? Okay. Ako, my mother and father are married, so I am a legitimate child, correct? So, my grandparents and both sides, no, both sides are my legitimate ascendants. Okay? If in the future one of my daughter will get married and they will have their own children, that apo of mine is because I have a legitimate daughter, then they marry, she married someone, then she will bear a child, and that child will be my legitimate descendant. Okay? Those are the individuals. If the killer kills any of those mentioned individual, then the crime is parricide, not murder, not homicide. Parricide. Sir, what if I am an illegitimate child? So, meaning my parents are not married. My grandparents are illegitimate ascendants. Again, if your parents are not married, your grandparents are considered illegitimate ascendants. If you're going to kill your grandparents, illegitimate grandparents, then that is not parricide. That is just homicide or murder. Okay? Clear? If, again, my daughter will have a child and she is not married when she has a child, then that child is my illegitimate granddaughter or grandchild. If I, God forbid, no, if someone kill a legitimate grandchild, that person is not liable for parricide under the law. But if the person kills his or her illegitimate children, no, then he will be liable for parricide. Sir, hindi sinabi legitimate or illegitimate parents. Pag parents, no, from the fact that you are, if you, it can be proven that that is your parents, whether they are your legitimate or whether you are a legitimate or illegitimate child of your parents, then it is still be considered as parricide. Okay? Easy lang yun. Okay? Death of physical injury under exceptional circumstances. 247, very controversial, very common. Okay? I want to discuss this because this is also a favorite question. What are the elements under Article 247? Death or injuries under exceptional circumstances. It's already 11 o'clock. Okay. A legally married person or parent surprises his spouse or daughter. The latter must be 18 and living with them in the act of committing sexual intercourse with another person. No? He or she kills any or both of them or inflict upon any of or both of them a serious physical injury in the act or immediately thereafter. He has not promoted or facilitated the prostitution of his wife or daughter, or that he has not consented to the infidelity of the other spouse. Then that person is liable under Article 247 and will be meted a penalty of destierro only. Okay, what is the scenario so that you will have a clearer grasp of Article 247? If I am a married man, no, if I caught my wife on the act, no, the term is caught on the act of committing, no, sexual intercourse, in the act of committing sexual intercourse, and if I kill any of them or both of them, then I will not be held liable for parricide or murder, no. I will be held liable only for destierro, no. The penalty to be imposed is only destierro. What you need to understand is in the act of committing sexual intercourse, if you caught if you caught your husband or wife, no, in bed with another person, but they are not on the act of having sex, no, on the act of having sex, then you cannot kill them, no. You cannot make use of Article 247 if you kill both of them, because this is a very strict and controversial article, no. You need to caught them in the act of committing sexual intercourse. Pagtapos na silang nag-sex, no, pagtapos na silang nag-sex, na nahuli you and you caught them, no, in the same room, in the same bed, you cannot use Article 247 as a defense. And then you need to kill them, no? You need to kill them or inflict physical injuries to them during or immediately after, no? In the act or immediately thereafter. Okay. So, for example, what do you mean by this? For example, you caught your spouse having sexual intercourse with another person, and then you decided to kill them an hour after. Wala na, hindi na. Because dapat immediately thereafter, pag nakita mo, bang, that's it. But if you provide, no, you provide considerable time, and you did not do nothing, you did nothing, and you just allowed them, you know, to continue what they're doing, or you know, to get dressed, and you still have time to recollect yourself and decided to kill them, then you cannot use Article 247, because under the law, no, this is Article 247. The law gave you, no, the law gave you parang a semblance of authority to kill, because it is understandable that you are in shock, no. It is a normal reflex, normal reaction to the situation given to you, no, or that is presented to you. It is understandable for you to be enraged by the infidelity of your spouse. But if you are given time, no, to compose yourself and to discern, and yet you still decided to kill them, then that is murder or homicide already, because it is intentional. In Article 247, what the law says is that the act of killing was unintentional, but it was merely provoked by the infidelity of your spouse, or even if your child, no, if your daughter, no, not son, it should be a daughter, no, who is under 18 and is living in your own house. If you caught her having sexual intercourse with another person, then the law, and you kill them, then the law will only penalize you for the crime of distier, for the penalty of distier. Then, according to jurisprudence, no, sexual intercourse does not include preparatory acts. What do you mean? If they're still in foreplay, meaning they're still kissing and caressing their private or parts, then that is not sexual intercourse. What is defined as sexual intercourse under the law is penetration, no, to the vaginal orifice or any other orifice in the body, may it be mouth or the anus. Okay? There must be, you need to catch them on the act of penetrating to any other orifice. Okay? So, for example, bakla yung husband mo, nakipag-anal sex sa ibang lalaki. So, if you kill both of them on the act of we are all adults here, so I need to discuss what is provided by the law. Don't make any malice out of my example. So if you killed your husband and his lover during the act of anal penetration, then you are justified of killing both of them. But if you caught them only kissing in your bedroom, even though they are without clothes already, then you cannot 447 cannot be applied, because since this is death under exceptional circumstance, the law, the jurisprudence, and the Supreme Court in catena of cases always held that the element should be specifically present. So if the law said that the act of sexual intercourse, what is defined as sexual intercourse is penetration. So if you just have foreplay, kissing, caressing of private parts, then that is not sexual intercourse. But, fingering a woman, no? Fingering a woman or fingering a man, because there is still a penetration to an orifice, that is still considered under the rape law as sexual. No, diba? Sex under rape under sexual, I forgot the term. Not sexual abuse. I will remember it later. Basta, what is important here is that there is a penetration to any of the orifice. May it be mouth, anus, or vaginal orifice. Okay? Murder. What is murder? That a person was killed and the accused killed him, obviously. And then the killing was attended by any of the following qualifying circumstance. Okay, in this case, any of the qualifying circumstance will not only impose if a person killed another person without this attending circumstance, no, without of these qualifying circumstances, the crime is only homicide. Okay, if you kill someone without using, let's say, treachery, no, you just had an altercation, no? You have verbal altercation, and that escalated to physical confrontation, and because of your superior strength, no, you were able to kill your opponent, then that is homicide. But if you kill an individual under these circumstances, the nature of the crime will be changed from homicide to murder. Although homicide and murder is technically the same crime, it is really a punishment or a crime of unjustly killing an individual. But murder carries a higher penalty. Okay? So what are the qualifying circumstances? Number one, treachery. So, you did not, pag pinatay mo through treachery, you use tricks, no? you use machination schemes to ensure the killing. Like for example of tricks, you gave poison to an individual, no, you gave an poison to individual, and you mix the poison with some drinks in order for the taste of that poison or the smell of the poison not to be discerned or cannot be discerned by the individual, or cannot be smelled by that individual. Then that is treachery. No, you use some scheme in order to perpetrate the crime, taking advantage of superior strength. Like for example, you killed someone who is, let's say, you are a bodybuilder, no, a bodybuilder at your 20 or 30, and you killed an 80-year-old frail man, because you punch a 80-year-old man who is very frail already. That is superior strength. But if both of you are, let's say, of the same circumstance, same middle age group, say almost the same body build, almost the same height, no? Or even if parang mas patanggat ka lang ng konti, but at least in a similar circumstance, no? Because not an it's very difficult for you to say na superior strength, because most often than not you will have the person that you will be encountering, no, that the strength would be unequal. It would be very hard to quantify if both individual are of the equal strength. What is is what is provided under the law is that the difference in the strength, no, the difference in the strength is very marked, no, meaning even if without any debating, an 80-year-old who is very frail and a 30 or 20-year-old bodybuilder, there is really a difference of strength. But if the man is 50-year-old triathlete versus a 30-year-old, let's say, with no athletic endeavors, then maybe, no, again, this is dependent upon the appreciation of the judge, no, if there is indeed a superior strength involved. Okay, I just want to capitalize or to give you an example. With the aid or armed man or armed men, with the aid or armed men. So you use someone, or you the killing was perpetrated using armed men, no? So you hired some goons to kill your enemy. So that is murder. Okay? Or employing means to weaken the defense. Like for example, if you want to quarrel, you intend to kill, no? You have the intention to kill your friend because you were jealous, and since you know that you cannot kill your friend if in a normal circumstance, because your friend is physically strong or is physically stronger than you, so you poisoned him or her, or no, not necessarily a poison that will kill him, but will only weaken his defenses or his physical strength. Then that is one of the example of weakening the defense of the means of person to ensure afford impunity. In consideration of price, reward, or promise. So if you kill someone because you are promised to be paid a considerable sum of money, then you, as the murderer or the person who execute the crime of murder, will be liable for murder, and then the person who paid you to kill that person will also be liable as a principal by inducement or through conspiracy. Okay, by means of inundation. Okay, you flooded, no, you flooded the house or a community. Fire, you use fire in killing. So um, sorry. poison, explosion, shipwreck, stranding of vessel, derailment, or assault upon a streetcar or locomotive, fall of airship by means of motor vehicles or with the use of any other means to great waste or ruin. Okay. On occasion of any calamities enumerated in the preceding paragraph, or of any earthquake, eruption of volcano, destructive cyclone, epidemic, or any other public calamity with evident premeditation. So, you kill someone during earthquake, and you intend to use that earthquake to perform or to execute your crime, no? Or there was a flood, there was a typhoon, and you use it to your advantage to kill that someone, then you can be held liable for the crime of murder. With the event with evident premeditation. What is evident premeditation? Meaning you plan it out. No, you plan it out. Meaning you observe. For example, one of a common example of evident premeditation is that when killing someone, you observe. No, you observe the day-to-day activity of the individual. You know what street she will go or he will go. What street where he or she commonly wait for a car for his or her ride, no? And what are the common foods that he ate so that you can poison him or her. So it means evident premeditation is that you really intend to kill a person using a plan, no? You plan the death or you plan the killing of that person. That is evident premeditation. With cruelty or by deliberately and inhumanly augmenting the suffering of the victim or outraging or scoffing of his person or corpse. Like say for example, before killing an individual, no, you tortured him or her, you raped him or her. That is an added what do you call that? Added form of cruelty, no? So that can be your crime will be qualified into murder. Or after killing the person, you outrage, no? You parang binastos mo yung corpse, no? Pinagtataga mo, chinap-chap, 'di ba? That is very common, the chop-chop lady, no? The murderer chop his or her victim. So whatever the circumstance of the death or how it was performed, the mere fact that you have outraged the corpse of the victim will make your crime into murder. Um, those circumstances that I mentioned, no, that will qualify, or the attending circumstances that I have mentioned that will qualify the crime of homicide into murder doesn't need to be present. All of them need not to be present. At least one of those attending circumstance will make the crime qualified from homicide to murder. Okay. This is also very important, no, for fiscal, no, when they will file a case, no, criminal case in court. There is what we call criminal information. It must be specifically alleged therein, no, that those attending circumstance, because if those were not alleged in the information and it can only be proven during trial, those can only be considered as aggravating circumstance and not qualifying circumstance, meaning the killing will only be considered murder and not the killing will only be considered homicide and not murder if those attending circumstances will not be pleaded in criminal information, which will be prepared by the fiscal. Okay. Sabi dito, treachery and premeditation are inherent in murder with the use of poison. So it only means to say that if you kill someone using a poison, automatically there is the element of evident premeditation. But then again, no use of poison in killing someone is one of the attending circumstance to qualify the homicide into murder. Okay? Homicide, that a person was killed, that the accused killed him without any justifying circumstance such as self-defense. Okay? That the accused has the intention to kill, which is presumed. Intent to kill is presumed in all cases when the victim died. Okay? So you don't need to for example, a person is killed, no? And or a person died, then the law will create a presumption that the person who killed that person is really intends to kill that person, because if that person only suffers severe injury, no, or some form of physical injury, the prosecution needs to prove, in order for it to be qualified as attempted or frustrated homicide or murder, and not just physical injuries, the prosecution needs to prove intent to kill. No, there are burdened with the proof. They are burdened to prove that the person acted with an intent to kill. But if the person or if the victim died during or has been killed, no, the prosecution needs not to prove intent to kill because it's already presumed. Okay? That the killing was not intended by any qualifying, homicide. Okay? Discharge of firearm. Very common among police officer. Okay, so I need to discuss this. That the offender discharges a firearm against or at another person, that the offender has no intention to kill the person. So if you just, fire someone without intent to kill, then that is discharge of firearm. There is a case I handled, no, which is very controversial because the person, my client, discharges a firearm, and he or she, I will not divulge that gender because it's still pending in the court of appeals. He or she did not hit the so-called victim, no, but he or she was still convicted for the crime of attempted homicide, which is so funny because no, the case should be discharge of firearm. Anyhow, and the under Article 254, no, the difference between Article 254 and murder or homicide or attempted or frustrated murder or homicide, other than the injury sustained, no, the main purpose only of discharging firearm is to intimidate, not to kill, but intimidate, okay, or frighten the offended party. Infanticide, no, the child was killed. This is also common, that the deceased child was less than 72 hours of age or 3 days, and that the accused killed the said child. Okay. Abortion, is abortion infanticide? No, because under the law you need to be born, no, you need to be born, and you need to be born alive for you to be and if you are born alive and you are killed, then that is within 72 hours, no, within 72 hours, then that is infanticide. If the child that was killed is already 4 days old, then that is not infanticide anymore, because under the law, again, the child must be within the first 72 hours of his or her life. Okay? this is also one of the jurisprudence, no, involving infanticide. It says that when an infanticide is committed by the mother or maternal grandmother in order to conceal the dishonor, such fact is only mitigating. What do you mean? No, nanganak ka, no, babae, nanganak ka, ayaw mong malaman na nagkaanak ka kasi, you don't know the father of the child kasi nagbabar ka lang na you were drunk, then one thing lead to another and you get pregnant, and to conceal your dishonor, for to protect your name and the name of your family, you decided to kill the child. It's not an exempting circumstance but only a mitigating circumstance, meaning the penalty to be imposed will be lowered. Okay, that is what this phrase means. Okay, that would be all for module 13.